Welcome to our channel. Today I will be discussing with you your rights as a client of a lawyer. First, the attorney-client privilege. It's really a privilege between you and your lawyer against the universe. It means that other parties, including government authorities, could not use the information given by you to your lawyer, and legal advice received by you from your lawyer as evidence against you, the client. So the preliminary communication between a potential client and a lawyer are also subject to this privilege, meaning you did not formally hire a lawyer, but you went to see a lawyer. And that person is qualified, is admitted to the bar, and it's not sort of any kind of informal, friendly chat. You are looking for a lawyer. And so you share with him or her the specific facts and circumstances, and he or she give, or maybe did not really give, some sort of advice to you. That whole conversation is subject to attorney-client privilege. But it's your best, you're better off if you actually hire the lawyer formally and have a full-blown engagement letter. Then there's no question about the privilege in that circumstance. It is really a legal doctrine and a rule of evidence, sort of sharing your conversation with your lawyer from being discovered essentially by the government or other parties, of course, to encourage you to sort of freely share with your lawyer the relevant facts and circumstances, so that your lawyer could intelligently advise you with the benefit of that. So that hopefully, the quality of legal advice will be better. There are exceptions to this rule. Such privileges are usually lost if the communication occurs in the furtherance of a crime or a fraud, whether the lawyer knows it or not. Once it's lost, it's forever gone. Your lawyer could no longer assert that privilege on your behalf. And such privilege will also be lost, generally speaking, if the communication occurs in the presence of a non-client. So if you go to see a lawyer and you bring your friend along who has nothing to do with your case or your transaction, so that privilege will not apply, because it appears you do not care about that substantive communication being shared with, somebody other than your lawyer. And then second is the right to confidentiality. It means that your lawyer should not disclose any information of you related to the work the lawyer does for you, including the very existence of attorney-client relationship between the two of you. It is broader than a direct attorney-client communication in the context of giving information in order to receive legal advice. The source of the information may be other than a client. For example, if a lawyer represents a client in divorce or in any kind of transaction or any other kind of legal cases, right? The lawyer will receive information from the other side. And in the context of representing the client, that information, the lawyer also needs to keep it confidential. The information, again, may not be given in confidence as in the attorney-client privilege context. For example, in my first example, the friend is in a room while the lawyer is talking to the client. Whatever information the client shares with the lawyer is no longer subject to attorney-client privilege, but the lawyer still needs to keep that information confidential. There are exceptions to the confidentiality obligations of attorney or the confidentiality right of the client. For example, if the lawyer is implied or expressly authorized to disclose certain information just so that the lawyer could carry out the work, in order for the lawyer to negotiate or to litigate, right, the lawyer has to disclose some information to the other side, to the court, and that's just, otherwise the whole thing cannot work. And the client is also entitled to lawyers' undivided loyalty, meaning the right to be represented free from any kind of conflict of interest. I mean, so a lawyer could not represent any party whose interests are directly adverse to those of the client. Some of the conflicts could be waived. Some conflicts could not be waived. It's just common sense for a lawyer not to represent both sides of a buy and sale of a business, right, or a lawsuit. Some conflicts could be waived. For example, a lawyer who represents the company in general may be asked by one shareholder of the company in that shareholder's proposed acquisition of another small shareholder's shares in the company. If the company, the majority shareholder, and the small shareholder all waive any kind of potential conflict. But generally speaking, a good lawyer would disclose the conflicts to the extent could be foreseen. So your potential lawyer needs to run a conflict check before he or she formally signs up to be your lawyer. So you will need to give him or her the relevant information. For example, the identities of your adversary or other related parties that may be relevant to the lawsuit or to the transaction, whether it's a witness or any other kind of third party that are involved or directly or indirectly in a transaction. So that's why before conflicts are cleared, a careful lawyer usually would not give a potential client much substantive advice. Some clients just don't appreciate that. They don't understand that. They say, why is this lawyer not giving me anything? Does he really know his work? And a law firm usually will not tell you it's due to conflict that it declines to represent you. Remember, the fact that a law firm or a lawyer represent a specific client is confidential. The lawyer could not disclose that to you. So the right to file some information, right? It varies in different states and could be contractually stipulated, meaning that you could separately negotiate with your lawyer and spell that out in your law firm engagement letter. Generally speaking, a lawyer cannot withhold files and work products that have got binding legal force, meaning for a contract that has been signed by both parties. Submission to a governmental agency that has been made, even if the legal fee has not been paid. On the other hand, an attorney could usually refuse to turn over work product that has got no binding legal force. For example, you hire a lawyer to draft a corporate charter for you, but the charter has not been adopted or filed, right? And in that event, the lawyer could actually withhold that from you until you pay for the work. A client generally cannot access the internal documents of a law firm of a lawyer unless that document is related to the property or funds of the client. For example, the banking record related to your escrow money. And for matters billed by hour, a client is entitled to a detailed, itemized description of the work performed by your lawyer. And the customary practice among good law firms is that kind of hour will be broken down by 0.1 hour increments. And of course, you have a lot of substantive rights as a client of a lawyer or a law firm. You, as a client, have the direct access to the counsel. So if you try to reach your lawyer or email your lawyer, they could not only have their paralegal or secretaries answer your substantive legal questions. They have to answer that questions directly for you. And certain decisions can only be made by you as a client, not the lawyer. The economic terms of any transaction, whether it's the purchase price or other kind of ancillary economic terms, for example, the interest rate in a loan or the term of a loan, right? And the term of conditions of any kind of settlement, whether it's before litigation or after litigation, and each offer and counter offer in any kind of economic negotiation or settlement negotiation. And in the case of any kind of criminal case, you as a client have the sole authority and power to plead guilty or not guilty, or to demand a trial or to waive a trial. Whether you want a bench trial or jury trial, these kind of decisions. And at the end, if you don't like your lawyer, you have a right to terminate your lawyer, provided that you have to pay for the legal fee accrued prior to the termination, even if you don't have any reason, or if the lawyer, even if when the lawyer did not make any mistake, that's just your privilege. An attorney cannot terminate a client if doing so will prejudice the client, meaning if it will inconvenient the client to a great extent, or disadvantage the client, or make the client incur unreasonable amount of legal fee to sort of redo the whole work. This is the presentation for today. We are New York-based business and intellectual property law firm. We also have an office in California. You're welcome to subscribe to our channel if you are interested. Thank you.